Good evening and welcome to EmpowerU. I'm Betty Overstreet, the Executive Director. We have anybody here for the first time tonight? Oh, well, welcome. I'll go through all my scenario. I wasn't going to bore everybody else, so I'll bore you. EmpowerU started in 2010, and Dan Reganel was the brainchild of EmpowerU, and his vision was to present classes on all different types of topics all over the city. And EmpowerU used to travel all over the city until Dan took part of his warehouse here and made this wonderful studio for us. So it makes things a lot easier. His mission and the goal of EmpowerU is to engage you and for you to enjoy it, but most of all to empower you with knowledge. We do live stream. Almost every class that's here in the studio does get live streamed. So if you can't make it to the studio, you can always log in online and watch it from home. If you miss the night altogether, it is up on the website on our at empoweruohio.org we try to get it up within 24 hours so that you can watch it. So if you know anybody that couldn't come tonight and they want to see it, probably by Saturday and hopefully by tomorrow, it will be on our website. We are a free university powered only by donations, so we do pass around our little red buckets towards the end of the evening, and any donation that you'd care to give to help fund what we do, we really appreciate. Also, are you going to take questions during your presentations? Okay. So if you have any questions anytime during the evening, just raise your hand. Wait for one of us to bring a microphone to you so that everyone can hear your question. And I would like to go over a couple of our classes that are coming up. Next Tuesday, we have the class on Google. Dr. Robert Epstein is a senior research psychologist at the American Institute for Behavioral Research and Technology and the former editor-in-chief of Psychology Today magazine. Dr. Epstein's 2015 report, The Search Engine Manipulation Effect, or SEME, and its possible impact on the outcomes of elections has been assessed or downloaded more than 200,000 times. The report describes one of the largest effects ever discovered in the behavioral sciences, and because SEME is nearly invisible as a source of influence and leaves no paper trail for authorities to follow, it is an especially dangerous form of influence. That's a little bit about what it's about. If you go on our website, you can read more about what he's going to be talking about that night. I hear people say all the time, Trump's going to win next year. He doesn't have anybody to compete with. And while I agree with that, well, what if the election's stolen by Google? So I encourage you to come to that class or at least go online. And then next Thursday, we have a class called Chess, the Game of Kings. And I don't play chess. I've really never even had an interest in learning the game. But I am interested in this class because I didn't know that it had an effect on world politics and society. For instance, it influenced the discovery of the New World, and it almost prevented the American Revolution. So I'm really curious about, how chess did that. The other class I want to talk about that we have coming up on November the 6th is TED Talks. And we've sent out quite a bit on that. And that class, we're trying to get you out there to present some big ideas that you have. You'll have about 15 minutes to talk. We're going to be doing interviews next Wednesday. So if you'd like to talk, don't be afraid to get up here. What I've found is when you know your topic, it's not nearly as nervous. You're not as nervous about getting up in front of people. And nobody's the perfect talker anyway. So don't let getting up in front of people and talking keep you from presenting your big idea to us. Next, I'd like to have Dan come up, and we're going to give away the door prize. So pull out your tickets.
Welcome. It's good to see you all. And tonight we've got a very special 2 giveaway night. So we're going to have 2 lucky winners tonight. The first is Bill O'Reilly's new book, which I think is great. Bill O'Reilly, I didn't pick it up because so much about Trump. I think just Bill is a great writer. I've enjoyed many of his books, so I hope whoever wins this enjoys it. And let's have our guest draw a name. Not you, Betty. No, let's have Sean.
I'm messing them up.
Oh, you're okay. Okay.
So the first one arrives gets it.
That's right.
3150.
Last four numbers 3150. Who won? 3150. Going once. Going twice. Okay, Sean, let's pick a better one this time.
$3130.
3130, Mr. Janis in the back. Let's give Mr. Janis a round of applause. Okay, so the next one, it's actually two prizes in one. I told Betty, don't be scared by the prize, but it's just something I thought was so funny. It is a Where's Hunter t-shirt. And it's put in one of Frame USA's t-shirt frames. So you get two prizes in one. It is large, and if large isn't your size, then just keep it in the frame, and I know you'll all have a good use for it. So let's pick one more lucky winner for the Hunter, Where's Hunter t-shirt.
3142.
3142, all right. And your name again? Your name again? Susan. Susan's the winner. Way to go, Susan. Congratulations. Okay, so just a couple things I wanted to go over with you before we get started. Great to see you here tonight. We had so many people online the other night for the class. I think we just had a lot of people, so welcome everybody online. We're glad to have you. Glad to see more of you are coming on to our sessions online. I wanted to thank our team of Betty Overstreet, our executive director. Let's give Betty a round of applause. Our treasurer, Bill Roll, who's making a new batch of popcorn back there if you're hungry. Jay Grunke, our producer in the back, Jay. And appreciate all your help. So on this TED Talk session we're going to try to have 6 people talk for 15 minutes. And one of our attendees tonight, Jack, where you at, Jack? Are you hiding from me? Has agreed, he's going to come next Wednesday and talk about something that's important to him right here in the front row. So we look forward to hearing you, Jack. So surely a couple of you have things on your mind you want to talk about. Just talk to Betty in the back, get a time, come and let us hear your 15 minutes, and it'll be a lot of fun. It really, really will be. A couple other classes I wanted to tell you about. We advertised for the first time the documentary Armstrong that we're showing. That will be on October the 29th. One of the kind of fun things that goes along with that is that night Sharon Coolidge will be here from the Enquirer, and she will talk about the day that the Enquirer said, you need to go get an interview with Neil Armstrong. And she got in her car and drove to Indian Hill. He was one of the most reclusive people in the world. He didn't like to talk to anybody. She knocked on his door, he answered, and she interviewed him, and she'll be telling us about that before we show the documentary. It'll be a lot of fun. And how many pots of popcorn are we gonna go through that night, Bill? Only 2, you say? Okay, all right. So, but it'll be fun. We'll watch the movie. The movie lasts about an hour and 20 minutes, and we'll hear from Sharon for 15 or 20 minutes. It'll be close to a 2-hour class that night. So I told you all briefly a couple nights ago about this group called the Port Cincinnati. And this is the group that made the decision that FC Cincinnati wouldn't pay any money in property taxes on their new stadium, which of course has the impact of everybody who lives in Hamilton County. You get to pay more. And I had somebody send me a little note via email, which people do all the time. And they said, well, how could they do that? Who is this group? And I'll be honest with you, I went online, and other than their fancy website, this is the only thing I could find about them. The Port is a quote unquote quasi-public agency. That their motto is making real estate throughout Cincinnati and Hamilton County work. And their CEO is somebody by the name of Laura Bruner, who has a background in accounting. And when I hear the words quasi-public agency, what that tells me is that's a group that taxpayers cannot hold accountable. And that is exactly what they've done. They've made this decision by a group of people that we cannot hold accountable as voters, and it's always a scary thing when that happens. So yes, sir. They're appointed, half the people are appointed by Hamilton County Commissioners, and half the people are appointed by the city of Cincinnati. But what you'll find in government, we've got a guy coming Tuesday night to tell us a few interesting government stories. His name's Matt Miller Novak, before the Google presentation. It'll be fun. You'll find that more and more of these boards are being appointed by governmental agencies because they don't want to take the heat on decisions that they know you'll go back to them on. So they let quasi-public agencies make decisions so that you can't go in. If you send them a public records request, they'll say, we're not a governmental agency, we don't have to answer you. And then you'll send them 10, and then you'll have to threaten to sue them, and maybe a year later you might get a couple of records. I may send them a records request and ask them how many millions of dollars in property tax they gave away, because in Hamilton County, property taxes are getting so expensive. But that was interesting, so I thought I'd share that with you. And I have a little interesting arrangement up here, and I'm not going to tell you what it is, but when you get a chance, maybe at the end of the session, come and take a look at it. And whoever can tell me what it is might get a prize at a future EmpowerU session. So on to our main event tonight. We're so lucky to have Sean Maloney kind of be our expert gun, just our gun expert. And Sean is a passionate defender of the Second Amendment to the Constitution. He's a defense attorney and a member of the National Association of Criminal Defense Lawyers who practices in all arms of firearm-related law, including Second Amendment rights, criminal defense, federal and state restoration of gun rights, and federal NICS appeals. He's appeared as an expert witness in a variety of civil lawsuits related to firearms. As an attorney, Sean's law practice focuses on defending the rights of the law-abiding gun owners who are forced to use their firearms in self-defense. I was just shocked when I saw this video. I don't know if you'll talk about it tonight. I almost asked Jay to play it, of Beto O'Rourke saying, well, we'll just go into people's houses and we'll just take their guns. Like that would be easy to do. Like the first time. And it's kind of appalling to me, and I don't know if Sean has any thoughts at all, but we're just so fortunate enough to have him tonight. Let's thank him for coming. Thank you, Sean.
You know, I haven't planned on talking about Beto O'Rourke, but I'll be happy to. First, I wanted to thank Joe Eaton for coming. Joe, wave your hand, everybody. I want to talk about Joe a little bit. He does more for firearms rights and protecting our kids. He's one of the founders of the FASTER program with Buckeye Firearms, where how many people have you trained? 3,000 school staff members to protect our kids. So, and first aid. So Joe, thanks for coming. I know you're a busy person. Also, you can't see him here. You can't see him here, but David Weber is the new representative from the National Rifle Association for the state of Ohio. He does Ohio, Pennsylvania, and a few other states also. And he's been working hard to preserve your rights, even though no one will ever see him. So David, I know you're looking at it. So, you know, thanks for everything you do also. Beto O'Rourke. Now, do you folks remember that for years and years and years, we were all crazy. Nobody's ever going to take your guns. We don't want your guns. Well, now they're coming out and saying it. They're all saying it, and they're all applauding the fact that yeah, we're going to go door to door and we're going to take your guns. And to have a man who's going to swear an oath eventually to protect and defend the Constitution of the United States, telling people and admitting that, yeah, we'll send the police door to door. But if they're going to fight back, he doesn't care. So it's interesting that we're in a time right now in the history of the United States where these people are openly running for public office in the highest office of the land. it's concerning. And that's why it's so important that you're here, because the only way that we can defend our rights and continue to defend those rights is to stay educated. We have to talk. We can't be afraid to speak out. We can't be squelched at all, because that's what they're depending on. That's what the media depends on. They're trying to talk us out of being Americans, and we can't let that happen. So I'm happy we're all here. I have some information, and Joe, you may have saw this. It was on Buckeye Firearms leaders list. You know, we're talking about parts of Senate bill that I'm going to be talking about tonight deals with correcting the reporting systems. And the reporting systems in the state of Ohio is kind of a mess. When someone's convicted of a certain offense or a certain crime or committed to a mental institution, that information is supposed to be fed into a portal, and it goes in the National Crime Information Computer System. So if a person who has just been let out of jail after 30 years for murdering somebody, he's under a lifetime disability and can't own a firearm. Well, you got to make sure that information gets in. And we've been very lax in the court system, really, in America. And in Ohio, you're looking at maybe only 20% sometimes of that information gets entered. They did a study in Cuyahoga County, and they had a stack of papers this thick, 2 or 3 years worth, that had never been entered because people didn't have the time or didn't have the ability. So there's no statewide warrant tracking system, but they estimate that there's over 500,000 open arrest warrants that haven't been entered, so anybody knows what's going on. Obviously, when you have a warrant out for your arrest, you're also under a firearms disability. So what the governor wants to do is mandate that Tier 1 warrants be entered into leads and NCIC within 48 hours. And Tier 1 warrants are murders or felonies. The Ohio Department of Public Safety study found that of the 217,052 Ohio warrants and leads, many more are never entered. Only 18,117 were entered into NCIC. An additional search conducted by the U.S. Marshal Service found that 17,552 of the total warrants and leads are for some of Ohio's most serious offenses. However, 58% of those warrants were not even entered in the NCIC computer system. So how many of these people have been pulled over for traffic violations? They do a check, they're fine. And that's the failure of our government. I don't care where you cast the blame, but it needs to be fixed. You can't start talking about drafting new legislation and giving us law-abiding citizens some more laws to have to follow when you're not even trying to enforce the existing laws on the books. So by way, I'm an attorney. I'm practicing law for, I guess it'll be 30 years pretty soon. So I have to tell you that this seminar is legal information only. It does not constitute legal advice. If you have particular needs and need an attorney, go out and make sure you find competent legal counsel. And I always like to say, no attorney-client privilege is created by me answering questions for you tonight or us doing it, but mostly because you're not paying me. You're supposed to laugh. That's a joke. Now, remember what I'm talking about tonight is pending legislation. And I will guarantee you that it will look nothing like it looks right now, 2, 3, 4, 5 months, or even next year whenever this gets done. In fact, probably a large amount of what I'm going to be talking about tonight won't even exist in a few weeks or a few months. That's just legislation, and that's just how things start, especially with this House or this Senate bill that the governor crafted. I know Larry Householder, the Speaker of the House, he has competing legislation that he's drafting. It's the Plummer bill. The mayor of the ex-police chief of the city of Dayton, or maybe Sheriff Plummer, pushed that piece of legislation. And I want to talk about, if you heard the cries that really started this was after Dayton. It was a terrible tragedy. And remember the cries of do something? To Mike DeWine, do something. And essentially, what I'm going to be talking about is the governor's office trying to do something. And I liken the cry for do something as having a flat tire and buying a brand new battery to fix it. Because that's what we're doing when we just say do something. Because nothing in here that I can tell would have stopped any of the killings in our lifetime. It just wouldn't have. It didn't apply. You know, you talk about mental health and predicting when somebody is going to commit one of these heinous crimes. It can't be done, as evidenced by the fact that the Dayton killer had receipts in his pocket from a psychiatrist. that he was visiting under current treatment. And if your doctor who meets with you and who's talking with you doesn't know you're homicidal, then how in the world can anybody else know that? And so we have to always consider the fact that, you know, you can't legislate the evil out of a person's heart. And sometimes bad things happen. And more often than not, we just have to be prepared as individuals to be able to face that danger. Whether you decide to go out and get a concealed carry permit and carry your own firearm or whatever else you want to do. And there's a lot of people that I know that flat out just don't go anywhere anymore. And the good link I want to give you is legislature.ohio.gov. If you want to enter that lawsuit or just Google Ohio Legislature, all the bills that are pending and all the information is on that website. It's a great website. If you want to read this bill, this is the bill I'm going to be talking about tonight. So I had to pare this down into about an hour. It's a huge piece of legislation. Anybody who wants it, come on up here and grab it. I should have them do a drawing. It's a piece of history, but I guarantee you, like I said, it's all going to change. Now, I'm only going to concentrate on about 2 of the 17 points in Governor DeWine's plan, but I'm going to touch upon everything else. But I'm going to talk about the 2 main ones, which really deal with firearms background checks and the mental health protection orders that they're proposing. So I want to take us all back to school for a little bit. For me, it was back to law school. For some of you probably, the older folks in here, you've received this knowledge in your education in high school, but I can guarantee you they don't teach it anymore. So I want to talk about a couple of legal terms that will help us as we move forward. And it's related to the voluntary background checks to obtain what's called a seller's protection certificate. Now, you're going to learn that even though they call it a voluntary background check, it's far from voluntary. And you're going to understand why, and you're going to understand how flawed that is in itself. So the first thing I want to talk about is scienter. I don't know if anybody's ever heard the term scienter. It's a Latin term, and I still have my Black's Law Dictionary on my desk because, you know, a lot of it's Latin, and I never learned Latin, certainly. So scienter is Latin for really knowingly. That a person has previous knowledge that something wrong, typically used to signify a person's guilty knowledge. I knew it was wrong, but I did it anywhere. So I had scienter. Under Ohio law, Revised Code 290122C, a person acts recklessly when they needlessly, with heedless indifference to the consequences, the person disregards the substantial and unjustifiable risks that the person's conduct is likely to cause a certain result or is likely to be of a certain nature. Basically, I knowingly did something wrong. And that's going to become important as we move through this. The next part of the code deals with when a person acts negligently. So first you have reckless, I knowingly did something, and then you have negligently when I may know, but I probably don't even know I did anything wrong. So under Ohio law, negligence is when a person has, because of substantial lapse of due care, the person fails to proceed or avoid a risk that the person's conduct may cause a certain result or may be of a certain nature, may happen, may occur, may exist, we don't know, but that's a standard, and you'll understand why I cited that. And scienter for negligence is really non-existent because I don't have to have a guilty mind or a guilty knowledge that I did something wrong. I negligently did it, I didn't mean to do it, or I didn't even know I did it. And you'll hear where there's a lot of cases where people are under a firearms disability, which means they can never own or possess a firearm. They don't even know it. In fact, they've been buying firearms for years because it's not in the system. Now, with that knowledge, let's look at the proposed voluntary background check created by Senate Bill 221, which was the designation this was given when it was just introduced. Currently under Ohio law, furnishing firearms applies to crimes of recklessness. So if I recklessly sold or transferred or lent a firearm to someone that was under a disability, so I knowingly did it. So under criminal law, if I knowingly do something, I'm reckless and I'm responsible for that. I run a background check. I know that, I'll use Joe, is a prohibited person. He can't own a firearm, but I sell it to him anyhow. Well, that's recklessness. Senate Bill 221 proposes to lower that standard for furnishing firearms to negligence, which is a civil standard. It's not even a criminal standard. Negligently selling, lending, giving, or furnishing my firearm or dangerous ordinance to any person prohibited. Scienter is, well, it's not there. Under negligence, there really is no scienter. I don't have to have a guilty mind or guilty knowledge. I just want to show you how they're changing the existing Ohio law to try to suit a purpose that I'm not sure exactly how we're trying to get there. And I can tell you, I had several arguments with the administration that you can't do that. You can't take a recklessness criminal standard and put such a low standard of negligence, which is a civil standard. Those two don't mix. And all it does is make basically anybody who fails to run the voluntary background check responsible potentially for something down the road. Well, how is that voluntary? You know, I had the conversation, well, all you had to do was run a background check. Well, but it's voluntary. If I'm in front of a judge 20 years later because somebody that I gifted a firearm to or sold a firearm to ended up being under a disability and I didn't even know that and he didn't know that, and I'll talk about that in a little bit, I'm still responsible and I had no knowledge of what was going on. And the judge is going to say, well, Mr. Maloney, all you had to do was run a background check. It was voluntary. Well, wait a minute. If the only way I can stay out of trouble is by running a voluntary background check, that's not really that voluntary anymore. And I asked people in the governor's office drafting this bill, I said, then just call it what it is. You're forcing people, the private sale of firearms, the transfer of firearms, to do a background check. Whether it's your next door neighbor, Joe and I have hunted together for 10 years. We've shot together. He's a great guy, family man. I have no idea. He seems like a perfect person. I sell him a firearm or I gift him a firearm. Well, he's under a firearms disability for something that happened 20 years ago. He doesn't know it because you're not really told you're under that disability. Plus, he's been buying guns for 20 years because the government apparently doesn't know it, but they find out, and this happened when it became NICS compliant with concealed carry permits, that he was under a disability. So now I'm responsible for doing something that I legally thought I could do that he didn't even know that he couldn't do. The problem I foresee is that given this voluntary background check system, it sets up a scenario where anyone who fails to go through that process acts negligently by failing to perceive a risk and thereby exposes himself to a conviction for a felony of the third degree. And not only did they take a high standard of knowingly doing something down to negligently, I may have done it, I don't know if I did it for sure. So they lowered the standard, they doubled the penalty. So now that I can negligently transfer a firearm to Joe, with he not knowing he's under disability and me not knowing, guess what? Instead of serving 16 months in jail, I can serve 3 years in jail for that. For gifting a firearm or selling a firearm or letting someone borrow a firearm that was a prohibited person. So, you know, I don't support the expansion to a crime of negligence in this context. In contrast, the federal law uses even a higher standard of knowing, again, knowing or having a reasonable cause to believe. So again, it's a knowingly standard even in federal law. And I think lowering the Ohio standard of negligence really just makes no sense and puts us, law-abiding citizens who want to do the right thing, under a very difficult situation. The voluntary background checks apply to any transfer defined under this new bill has more than just sales, gifts, loans, and it's any furnishing. So I don't have to sell it, I don't have to loan it, but give it to him to use it a day. We're hunting. He's a prohibited person. He doesn't have a gun, but I don't know that. I'm trying to cross the fence. I say, Joe, you hold this for me? I just committed a felony when I just transferred that firearm to his arms. So the law goes that far, and we have to pay attention to that, the unintended consequences. So hypothetically, currently, if I, as a transferor, seller, or lender, require the transferee, buyer, or receiver to obtain a certificate by having a voluntary background check performed, and that's what they're going to do. They're going to issue, you're going to have a voluntary background check performed. They're going to issue a certificate that's good for 90 days. And so when you go to buy a gun from somebody, you can say, hey, I have a certificate. So that's what they're asking you to go get. And by the way, I asked over and over and over again, our concealed carry permits are NICS compliant, meaning if we have an Ohio concealed carry permit, NICS already knows that we're compliant people, we're not under a disability. So if I go to a firearms store right now, I just show them my concealed carry permit and I fill out the application, but they don't run the NICS check because they don't have to. But they don't have that in here either. So Joe can't show me his concealed carry permit, that doesn't work. And I asked them over and over again to kind of do something about that. So now they have this voluntary background check performed, you know, the instant background check to see if Joe's prohibited. And I transfer it anyhow. When I know he's a prohibited person, then clearly I'm reckless at that point in time. And that's what the law is designed to do. When I knowingly do something wrong, then I should be punished. But what if Joe passes the NICS check? Because you won't believe how many people have been purchasing guns for 15 or 20 years and then go to renew their concealed carry permit or suddenly try to get their firearm purchased, and all of a sudden they're prohibited after all these years.
Sean, we have a question online.
Okay.
This person is asking, is making the observation and asking a question. The bill would have a voluntary process in which a non-FFL may transfer a firearm to another non-FFL, where transfer involves a sale, loan, gift, etc., furnishing a firearm. Under the revision, only the transferee can initiate a background check that results in the seller protection certificate. The petition, including name, address, social security number, and other info, has to be filed with the sheriff. Does the use of a social security number frighten you, and do you feel it is beyond the normal purpose of what an SSN should be used for?
Obviously it has been, but the SSN has been abused for years, probably my lifetime. The social security number is only supposed to be used for social security purposes, but it's become our identification. And I'm surprised that they're requiring a social security number, because the federal NICS check doesn't require one. Name and birth date really is all you need in place of birth, but they're requiring a social security number at the same time. And I'll get into this later, but to initiate this whole process, I have to say, Joe, I got to have a seller certificate. So Joe has to go and get one, and we'll talk about what that involves in a second. So I don't know, somebody's under disability. They don't know they're under disability, because trust me, folks, there's a lot of people that are like that. Should I spend the next 3 years in jail because he didn't even know he was under disability? Then how possibly could I? And even if I would have ran that voluntary background check, he would have came back as all right, but 2 or 3 years later, the system catches up to him, and now he's a prohibited person. Now he commits a crime. Now they're going to trace that firearm back to me. On the other hand, if I lend or sell a firearm to my neighbor, Joe, who I've known for 10 years, have no knowledge of wrongdoing, have went hunting or ranged with him in the past, and have no knowledge that he is a prohibited person, and neither does he, and I sell him an old shotgun he's admired for years with no Sienna. Remember, I had no knowledge that anything was being done wrong, and I sold him my gun. You know, I'm guilty in negligence in transferring it. So on one hand, if I knew that he's a prohibited person because I know he's under disability, well, then obviously I'm reckless. But if nobody has any knowledge at the same time, I'm still responsible under a negligent standard. So to have such a low standard doesn't make any sense to me. And many of the arguments I had with administration over this bill, I said, you can't lower the standard from recklessness to a civil standard. I said, that makes no sense. And I still don't know why they've done that. But you know, we're gonna fight it, and we'll see what happens at the end of the day. And like I said, on top of lowering the standard, they double the penalty. So the problem I foresee is that given this voluntary background check system sets up a scenario where anybody who fails to go through the process acts negligently, and you got to remember that, by failing to perceive a risk and thereby exposing themselves to conviction for felony to the 3rd degree. So I don't support the expansion of the crime of negligence, like I said earlier. In contrast, federal law uses a higher standard. In this case, we should use a higher standard also. There's no sense of punishing the law-abiding citizen in Ohio, but isn't that what always happens? Something happens with a car, with a knife, with a baseball bat, and it's the law-abiding citizen that suffer the consequences. And you know, it happens again because we have to do something. So, Mr. Maloney, why did you transfer the firearm to a prohibited person? Your Honor, I didn't know. And neither did he. But all you had to do was run a voluntary background check to avoid the chance that something may occur. Never mind that I'm totally innocent. I had no criminal intent. But, you know, in front of a judge, he's going to say, all you had to do was run a background check. So if under this proposed legislation, if I do have Joe run a background check and he gets a certificate, then I'm absolved of all criminal liability. So if down the road something happens, then that I can't be charged with criminal negligence and serve 3 years in jail. But guess what? It doesn't protect me under civil. The family of whoever Joe injured with that firearm can still sue me, get my house, and get every penny ever made. So it doesn't provide any protection there also. So really, that doesn't make a lot of sense. So you talk about timing and procedure for the voluntary background check. You know, time is the essence in sales, no matter what, if he's going to go hunting or if you want the gun in a reasonable amount of time. Well, one thing that they haven't done yet is they haven't asked the sheriff's department, any of the sheriffs in the state of Ohio, do you have time for all these people to start running in here and asking you to run background checks so I can get a certificate? I know in Butler County, if I want to renew my concealed carry permit, I make an appointment and they're about 2 weeks out. So I have to wait 2 weeks. So now my instant background check is 2 weeks before I can even get in. And under Senate Bill 221, once I get in, the police have 3 days before they're required to run it. So best case scenario, I got to wait 3 days. Then the Bureau of Alcohol, Tobacco, Firearms, and Explosives has another 3 days to come back with an answer. Now, there are times when they don't have that answer in 3 days, and so there's a default giving. If in 3 days they can't figure out what they're doing, then the person gets to purchase their firearm. But guess what? That default's not under Ohio law, not under this bill. It says basically that you have to wait until you get an answer. But they don't define what that is. And I can tell you, folks, sometimes it's a week, 2 weeks, 3 weeks, 3 months, a year. Sometimes you'll never get an answer. So they have to try to figure out how to either get the default proceed involved, or they have to try to figure out something to do. And like I said, nobody asked the sheriff's department, so I can tell you that they've hired additional people. They don't have the staff. These folks are already working 8 hours a day processing people all day long. To have other people trying to come in to do a voluntary transfer, it's not going to work. Now, safety protection orders. Red flag. You know, and I feel bad for calling a red flag because my first meeting with the governor's people is I said, forget the word red flag. The only reason why I mention it is because you all know what I'm talking about. Red flag means something different than the safety protection orders, and that's what the governor is termed as. Now, they were going down the right path, and this is something that I brought up and with the help of a friend of mine who's a prosecutor for Butler County. He said, Sean, we were in a telephone conversation, why did all these people try to start talking about running red flag in the state of Ohio? We already have something that's better than red flag, and we do. We've had section 5122 of the Ohio Revised Code for decades. And what that is, it requires that if a loved one or a family member or a police officer comes upon a person that is in crisis and obviously is going to harm themselves or others, and people are concerned, well, that person could be quietly taken for immediate medical treatment to an emergency room or to a hospital where for 24 hours, they'll have care given to them to determine what's wrong. And then at that time, if they're fine, they're not under a mental crisis, then release. But if they are, they can keep that person for another 3 days for proper medical treatment to try to diagnose the situation and treat it and get them able to enter back in society. And then after 3 days, if you're still a danger to yourself and others, you're in crisis and you can't really be let out either in a kind of a halfway house or a shelter or for treatment outside, then they can keep you. And after 3 day period of time, and this has been the law and they've been using this for years, after a 3 day period of time, if you need further medical treatment, the only person that can decide whether you can get that treatment is a probate judge. You have to go in front of the probate judge with a psychiatrist or psychiatrist, law enforcement with witnesses on both sides. Everybody's represented by counsel, so the judge can take the evidence and hear everything and decide before we're going to make a decision to keep somebody hospitalized against their will at this point in time, make sure it's done with due process and it's done properly. And so I applaud the governor for taking these steps, because removing the firearms from somebody in crisis does nothing. I'm at my house, I'm in crisis, they realize that, so they take 1 or 2 firearms or whatever they can find and they leave. So I talked to several psychiatrists about this, and they all said, Sean, if we did something like that, we'd be sued for malpractice. To leave a patient in crisis, aggravating them by taking their firearms or their personal property, and then expecting them not to be surfing the internet, how to make a bomb, not to grab their cars, their baseball bats, a Molotov cocktail. It's that people that are in crisis are not going to stop because you take one item from them. And so I applied to governor, because when you're using the existing law that's been done properly, and it's stood the test of time, it's been litigated, the Supreme Court has looked at it, and due process exists, then that was a good first step. But they kind of went off the rails, and we'll talk about that. Troublesome in this is, so you're dealing with somebody who is mentally deficient. If you've been adjudicated mentally deficient in America, that is a disability that keeps you from owning or possessing firearms. It's always been that way. But now what they've done is they've expanded, and there's several bills out there that have done this. They've expanded who can be pink slipped, or the people subject to the safety protection order, to include, at first it was just people with a drinking problem or alcoholics. Now it's chronic alcoholics or persons with drug dependencies. So all those functional alcoholics out there, the people, the soldier that comes home with PTSD and has a drink or two, you know, he had what's perceived to be a mental illness, and now he's got alcohol. Well, he'll be under a disability. And they've also made it so just chronic alcoholism or some kind of drug dependency that's really not well defined alone will put you under a disability, a firearms disability. So they're taking your guns and you're under a disability, and you have to file for relief from disability, which is kind of disconcerting, because chronic alcoholism and drug abuse has been in the criminal section of the Ohio Revised Code for probably 5 years as a debilitating factor or a reason why you can't own a firearm. You know, that puts you under disability for being an alcoholic. But the problem was in the criminal code, and I didn't realize this until I was reading this stuff, trying to figure out where they're getting it. So in the Ohio Revised Code in section 2923, it states that you're under a disability if you're a chronic alcoholic or if you're drug dependent. But guess what's not in the code? How do you find out you're a chronic alcoholic or drug dependent? There was no test. There was nobody saying that you are it. So how did you know? Did God come down and touch you on the shoulder and say you're a chronic alcoholic? Because there is no way for anybody to know, including the court system. So this was a section of the revised code that put people under a firearms disability and deprived them of a constitutional civil right, and nobody knew how you became that person. How do you become a chronic alcoholic, or who says you are? There was no way in the code, which I found that was interesting. So now they're trying to add that into parts of the code. Now, I said there's competing bills out there. I've read bills out there that there's section A defining when you're mentally ill. There's a lot of factors that can be and then or. And then what they did is they put under A, 1 and 2, chronic alcoholic or drug dependent. And so I said, well, have you just created or expanded who is mentally ill to include someone who's drunk or someone who's drug dependent? I said, you can't do that. I said, it's a different diagnosis. I said, it's a dual diagnosis. I can be a chronic alcoholic and I can be mentally ill, but not every alcoholic is mentally ill. And so that's what they did. They expanded what mental illness was, and they included it under mental illness. And I had a huge problem with that. As did another friend of mine, Ron Lemieux, we had huge problems. You can't do that. So they're trying to figure out a way to make that fit in there properly. And so in Senate Bill 221, what they've done is they've just included another provision that states that if you are diagnosed as a chronic alcoholic or drug dependent, then you're also under a federal firearms or under a firearms disability. What makes sense, because now there's a way, at least we know you're that way. They have it under the section for mental illness. So the same thing applies if they think you're coming down off DTs or you're smoking crack and you're shooting up the inside of your house and you're a danger to yourselves and others because of drugs or because of alcohol. They can detain you now, give you that same treatment, and decide whether you need ongoing treatment. And I understand where that came from, because one thing was they would arrest somebody. They would take me to the hospital, the emergency room, because they felt I was a danger to myself and others. They thought I was mentally ill, mentally deficient. So the police dropped me off. 4 or 5 hours later, the emergency room calls and say, hey, come and get Mr. Maloney and take him home. He's not mentally ill. Under the laws in the state of Ohio for privacy, the hospital couldn't say what was wrong with him. The hospital couldn't say, I'm a chronic alcoholic. The hospital wasn't allowed to say, well, I was smoking crack and I was coming off the crack and that's what was driving me crazy. So I'm not mentally ill, and out the door I went. And so I think this is what they're trying to prevent, but it's, you know, it's time to start getting some mental health professionals in there to figure out the proper way to do this. So I know where they're coming from and I understand what you're doing, but I don't think they quite have it yet. But that was a problem they're trying to fix. Again, they just want to make sure they remove the person from the firearms, but you still have to respect everybody's, all the other constitutional rights that are there. So that's kind of a problem. So now under RC 2923-133, which is a new section that's been added, it provides that a safety protection order upon medical examination and opportunity to be heard and represented by counsel, a finding of mentally deficient or chronic alcoholic or drug dependent allows a court to issue this protection order when they have probable cause that a person under a mental health or drug or alcohol firearm disability, if released and not detained, will have access to possess a firearm. So what they did, now they've said you're either mentally ill under this Senate bill, or you're a chronic alcoholic, or you're drug dependent. So now we have 3 ways. And I always ask this question, and I think ethically I'm allowed to make this statement, because as an attorney, I got to make sure that I don't disparage judges. But how many probate judges currently are going to risk their jobs not issuing a safety protection order when someone's hauled before them? Because you know what, if they make a mistake and someone dies, they're not going to get reelected. And so that always bothers me when someone's liberty is in one person's hand and that person can't be free from making the right decision. So the order then after I've been determined to be a chronic alcoholic, the police get an order that require them to seize all firearms, and they went beyond firearms in the state of Ohio and all dangerous ordinances or dangerous weapons. So think about it, folks. I want you to, in your mind right now, I want you to walk in your kitchen. And I want you to tell me what every dangerous weapon is. From the cast iron kettle you cook eggs with on Sunday after church, to the butcher knife, to the big long fork, to the glasses, to the bottles, to the firearms, to the knives, to the lawnmower, to the chainsaw, to the weed eater. It goes on and on and on. Can you imagine serving this warrant? All right, Joe, why don't you go to Sean's house and why don't you take all the dangerous weapons? So I think that's another can of worms that they're not prepared to. But you try to walk them through this stuff, and you know, you can't blame them. You know, people ask, well, were you involved? Well, absolutely, I was involved in consulting and looking at this legislation. It's not the way I wanted it, but I couldn't force them to do that. But of course, you're going to get experts in the field to ask questions to and help out, because you know what they were doing yesterday? Trying to figure out school funding for the 20th year. So they're doing school funding and they're doing firearms and they're doing everything else. So to get experts involved, you know, they're doing the right thing there also. And trust me, they use them everywhere. One thing that was good is that options for release of the firearms. People who have gun collections, whether they have 1 or 2, they have 300 firearms. Under this Senate bill, the firearms just aren't seized. Initially, they're seized by the police, but then you can file and those guns can be transferred to a family member, a respected person, an FFL. The guns can be sold, so they're just not going to keep them and let them get rusty in a corner someplace. So at least you have that option if, in fact, that's where you are. So you can have a trusted family member keep them, and then take it from there. There's probably a better way to do this. And if you don't do that, then what's going to happen is after the person gets out, he or she have to file a separate action for relief from firearms disability, which requires attorney, a new action, money, and everything going down that road. The common sense way and simpler way, and I keep nudging people, and I don't know why, you know, for 10 years, and nobody's done this yet. You don't need to put someone under a federal firearms disability, put them on a registry and go through everything so that when they're healthy again, They don't have to spend $4,000 or $5,000 to get their rights back. Simply make it part of the court order. I'm in front of a judge. The judge is going to have a judgment entry. I'm going to be under a court order. The court order should say that I can't possess or have any contact with firearms until I've been released by the court. And then 5 years from now, after I'm healthy and they come back in for one of my hearings, Sean Maloney's fine. He's not a danger to himself or society again. The judge can rescind that order and I can have my firearms rights back. Makes a lot more sense. I think when things are done like that, then every hoop, every piece of paper, every payment that they put on us, I mean, that's gun control, folks. They don't have to take your guns. They don't have to take your liberties directly, but they can make it harder. They can make it, if you look at Washington, D.C., sure, you had a right to own a firearm, but nobody did because you couldn't jump through all the hoops. I think Emily Gets Her Gun was a book written. She had just gotten Heller versus Washington, D.C., I think that was 2010, was one. She wanted to purchase a firearm. And she wrote a book about the steps it took for her in Washington, D.C. to purchase a firearm, and she entitled it Emily Gets Her Gun. It took her nearly 2 years to jump through all the hoops. And that wasn't even getting a concealed carry permit. That was just to own a firearm. And that's all changed now because of court orders, but trust me, it would still be the same if they had it that way. New changes under this Senate bill also include the increase of penalties for violations of 29, 22, 13. That's firearms under disability. I'm under disability, whether I know it or not, and I'm caught, I have a firearm. I'm not using the firearm. I don't threaten anybody with the firearm. Maybe I have a shotgun in the corner because I shoot rabbits in the morning, but I'm under a firearms disability. Well, they increased those firearms disability for the first time. So merely possessing a firearm under disability, I'm not using it in a separate crime. A first violation of prohibited persons would be a secondary felony. And then any subsequent convictions will be a first-degree felony. And the second-degree felony has a mandatory minimum jail time of 2 to 8 years. Now, we're talking about Mike DeWine, who ran on a criminal justice reform platform. This isn't criminal justice reform because almost every law dealing with firearms, they've doubled or tripled the time and the magnitude of the sentencing. And I can probably be pretty confident in saying that everybody in here realizes that a criminal isn't going to say, well, they just upped the crime of me possessing a firearm. I can serve 2 years now. I better not do this. That doesn't happen. They don't make the decision. They know what the consequences are, but they don't care.
Could you wait just a minute, please?
Live down there. What do you want me to do with it? Oh. But the kids come home from school, and if they're going to have supper, they take a shotgun, slip out around, and around dark, the quail all make a circle all tail, and he's got one shell and he shoots. You'll get the 10 or 12 quail, which they can have for the next 2 or 3 days to eat. But all these rules and regulations you speak of, they've never heard of, and it's a whole different world.
Well, and part of this legislation too is furnishing a firearm to somebody under the age of 18 for a long rifle or long gun, or under the age of 21 for a handgun. My own son or my own daughter in my own house, for me to allow them to possess and use that gun. And there of course there's provisions for supervision and things like that, but even leaving a firearm in the house where they can come in contact with it potentially can involve criminal charges there also. So there's a lot of things, a lot of blowback.
School and want to get supper, they get a shotgun and go out, and when they start to roost, they can get a whole cubby with one shell.
Yep.
That's just part of living in that rural area down
Where
there.
I grew up, it was. Yes? I don't do backups.
When you were just talking about if you were mentally, you had to be in front of a judge and they said that you had a mental problem, and I'm paraphrasing, sorry, but you said something about just a court order as opposed to going, would they, are you suggesting they would put that on the registry so then if you did do a voluntary firearm or a voluntary background check that would show up?
Yeah, in the court order, the warrants that I spoke about at the beginning, those are supposed to be in the NICS system. Court orders, putting me under a firearms disability should be in there also. But instead of entering me into the federal database as that, it can still be entered. And then instead of me being forced to do a restoration of firearms rights, which is a new proceeding with a new judge and a new attorney to get my rights back, which everybody has to do. If you're under a disability, you don't automatically get your rights back. You have to pay an attorney and you have to go get your rights back. So if he just did it on the court order, then it would be there on the judge's entry sheet that Sean Maloney is not allowed to have a firearm, and that's going to follow me around until I'm allowed to have one, and then that order is released. Because then it'll, because then, exactly, when the judge knows that I'm no longer a dangerous society, and I'm before the court, and the court says, Mr. Maloney, you're relieved from all community service, or you're relieved from all medical attention, they can automatically give me my firearms rights back.
Yeah, I appreciate what you're saying about the law, but my perception today is that we're dealing with a group of people on the left that don't really feel like they need to pay attention to the law, that they can just kind of do whatever they want. And we should have a rule of law, but how do you deal with people that are basically going to find some way to circumvent it and just do what they want?
That's what they're trying to do, and that's what this is all about. Another piece of legislation that impact our rights, and that's why. And those people that don't care about the law, they're always going to break the law. But guess what? We're the law-abiding citizens. If you're a concealed carry holder in the United States, you're part of the safest, most law-abiding segment of society. So applaud yourself. You know, you have the Uniform Crime Report, you have the CDC reports that show that beyond a doubt, the concealed carry firearm possessor in the United States is the safest, most law-abiding segment of society. So we're the law-abiding citizens, and they're always going to do that and keep trying to take our rights away.
Hi, this is a great topic you have tonight. I was curious, two questions, they're closely related. If, let's say out of guns that I've owned over the years and I'm getting older, and I have a son and a son-in-law. They're good citizens. Both of them have master's degrees and good jobs. But if I would decide to either gift or to sell for some nominal amount some of my firearms to my kids, basically, would I have to have the background check? And then number two, I know I've gone to gun shows before, and I think that the dealers always have been using the background check. But a lot of people who attend shows will, you know, break their shotgun down, put it over their shoulder, and you walk by and say, what you got there? Oh, that's an Ithaca. Yeah, it's a 1911. Oh, yeah, how much you want for it? And, you know, they'll have person-to-person private sales within the aisles of the gun show. And would that also affect that?
Well, keep in mind, this is quote-unquote voluntary. So the example you gave with your children or your son and your son-in-law, they don't have to have one, but you could freely run that background check on them. And in most other states that are passing legislation like that, I can't even use California, who signed their new legislation law, because that's so far off the beaten path. But yeah, you have to have that. In fact, there's going to be a ballot initiative that's being ran. They're going to have enough signatures, and they're going to put their quote-unquote universal background checks on the ballot. And we have to defeat that, because some of the provisions in there is, you know, they're saying that, well, you can transfer it to family members as a gift. But when you said we're sell it for a nominal amount, you can't sell it for some reason. So I looked at that legislation, what they're proposing. So that's coming down the pike, and that's going to require that every transfer of firearm be done through an FFL. Be done through a federal firearms license. So if I sell one or if I gift it to somebody, I have to have your background check ran. And what I always say is, how is the government going to know if I sold you my gun? Registration. The only way they know is if they register my guns. And that's why, you know, when you hear that 80% of NRA members agree with universal background checks, well, sure we do. Nobody wants a bad person to have a gun. But as soon as they say, but that requires gun registration, nobody wants that, because a universal background check means universal registration, means universal confiscation. Look it up. It's happened in China. It happened in Korea. It happened in the Soviet Union. It happened in Germany. Everywhere. It happened in Australia. Everywhere that they registered firearms, the government eventually took them. And we're smart enough to know that, and that's why we resist.
Could I ask a question, Sean? So on these laws that currently exist in Ohio, if I'm concerned that somebody is a danger to themselves or the public, let's say my friend Fred over here, all of a sudden I become concerned that he's a danger to the public. What do I do? Do I call the police first?
Yeah, usually there's restrictions that it has to be a family member or a law enforcement officer. So I call the police and I'm worried about Fred, and a law enforcement official comes over and takes a look at him and makes a decision that, yeah, he's in crisis or he's a danger to himself or somebody else. And the code specifically said that quietly, without fanfare, Fred's removed to a hospital. So nobody knows what's going on. But that's really how it happens under current 5122 law.
And then when Fred got to the hospital, would they then, the emergency room or their psychologist, they would also look at Fred and maybe send him home or keep him?
Yeah, they have, the way the law is written, they have the opportunity to keep him for 24 hours and examine him to make a decision, a determination of what's going to happen. If they need to see him for an additional time, they can keep him for up to 3 more days in crisis to give him medical treatment. Obviously, as a physician and a doctor, you're there for a reason. And then at that point in time, if Fred needs more care after that 3-day period of time, then he has to go and have a hearing before the probate court, and they got to decide that his rights are being protected, and you're just not turning into one flew over the cuckoo's nest and you're not being locked up.
So it could be 4 days before you see a judge. Jack has a question here.
Sean, how does a private individual go about performing a volunteer background check?
I'm going to get to it, but I'll tell you right now. So they talked about setting up a provision where Ohio created their own database, and you would do it solely within Ohio. They'd have their lead system put together with a NICS system, and they would try to run it that way through their own information, but they realized that's probably $100 million and years away from being able to do that, because really they like to have an app on a telephone. So what they're proposing right now is that and it has to be the purchaser has to go get a certificate. And so the first thing that has to happen is they have to show up at the police station, give them an ID, identify him, and then either have the background check done right now or make an appointment and come back, however the case may be. And then at that point in time, the sheriff's department has 3 days to run the test. And then the ATF has 3 days to answer, or maybe they'll never answer. And under Ohio law, if they never answer, you never have the transfer. So it's a complicated thing. It's a background check, just like you're going to a gun store to purchase a firearm or to a gun show to purchase a firearm. So that's the process. And as I mentioned, no one's bothered to talk to the sheriff's department yet to see if they can even do it. And then there's another problem. The NICS system can only be used when you're talking about transferring firearms and purchasing firearms, because we're not a point of entry. We're not a point of sale. So we don't run our own NICS checks. We contact the ATF by telephone or send the information on a computer. So really kind of what we're doing is the ATF really isn't prepared for all this either. Now, it's available right now under federal law, so I can take a firearm to a gun store. Joe and I are going to do a transfer, but I have to hand the gun to the gun store. They have to log it in to their registry. So now it's their gun. Then they run the background check, and then the sale can proceed, and then they log it out to Joe, who's the buyer. Well, that's kind of it's a good question. It's another problem. Under current law with the alcohol, tobacco, and firearms, they can only keep the information they get out the form 4473, which is your name, your address, and the gun on it for a certain amount of time, and then they have to destroy all that information. When Brady went into effect and they started doing background checks, we didn't want that, so they're supposed to destroy all that on the federal level with the ATF. But everybody who sells guns and is an FFL is required to keep those records forever, and then they're required, when they shut their business down, to send them to the ATF. But I don't know anybody personally who's ever done that. So that really is a backdoor form of registration, because if a Remington 870 is used in a crime and it's left at the crime scene, All they're going to do is they're going to call Remington and say, I got this serial number, who'd you sell it to? Well, I went to Freedom Firearms. They're going to go to Freedom Firearms and say, you purchased this from Remington October 13th, 2012. Can you tell me who you sold it to? So then they'll have information on who the store sold it to, but once it hits the streets, it's gone. Because anybody could sell it, and it could be, you know, like who knows where it could be. So, but that's as close as it gets to registration there, but. Mm-hmm.
We have an online viewer that notes that Ohio has a medical marijuana control program and is wondering if the red flag bill would conflict with that in any way.
I informed actually the governor's office when they were working on this, that this would be a great opportunity to take care of the medical marijuana issue, because it is a problem. Under federal law, of course, it's still a controlled substance. And one of the first questions on the Form 4473 is if are you an unlawful user of drugs? And if you have a medical marijuana card and you're using medical marijuana, you're violating federal law and you're an unlawful user, and that's an automatic denial to purchase a firearm. So when you're looking at the marijuana, it can't be used for that. Probably wouldn't be since Ohio has legalized it, but that's one thing that I told him, you have the perfect opportunity in this legislation to make it right. And I don't have the answer for that, but you have to figure out what you have to do.
My question is actually goes back to Dan's example, that if you call the police and you have a neighbor, perhaps that you're concerned with, police show up. I know we're asking a lot of a young man, a police officer, are they having training that they go and, I mean, the decision they make that day at that door can impact somebody's life, the rest of their lives.
Well, and it's not done lightly. And remember, these people are being transported. And when the police officer is fearing for their life or the person's life, they're taking them for medical assistance. And then an independent doctor is making a medical diagnosis of, is this person mentally ill? And if I let this person go home, are they going to harm themselves or others? And so you have the medical personnel is making that decision, because far more people than you can imagine are walk out the door and are allowed to go home because of drugs and alcohol, I know for sure in the past. But that's why I think probably the pink slip law under 5122 has worked all these years, because there's a lot of stopgaps there. You take you in, you have the immediate psychological evaluation or medical evaluation, and the determination is immediately made. If it can't be made within the 24-hour period of time, then they can still diagnose and treat you for an additional 3 days. But if they need to keep you longer than 3 days to save your life or to make sure you save other people's lives, then it goes before a probate judge, and then it's a hearing to determine to make sure that if they're going to take your rights away and they're going to keep you in a hospital if it's done properly.
Sean, if you report somebody under those circumstances, are you held harmless for that?
Yeah, because what happens is you're going to have the police department is coming to make a decision. He's interviewing and looking at the situation. And like I said, under current law, it's immediate family member. But one thing they did in California today and assigned in the legislation is anybody can turn in anybody. So can you imagine that mess? You parked in front of someone's mailbox. I mean, there's people out there that will do it. So, we'll see what happens, because, you know, we'll hear the stories and everything will be involved, but that's insane. Even when you have, when one person, even when it's a husband or a wife or a family member has the ability to drop a dime to have someone come over and potentially arrest you, interview you, that's never a good thing, because sometimes family dynamics are worse than anybody can imagine. And whenever one person has the power to use somebody or to wreck somebody's life, so to speak, they don't always use it properly. I mean, it's all
I'm going to take you out of Ohio. This week in Massachusetts, in Tisbury, in Martha's Vineyard, they arrested and took away the arms from a gentleman who was talking about it in a restaurant that the waitress overheard, called the police. They went to his house. He lost his job. He was a veteran, and they took all his firearms from him. Did you hear about that story?
No, it doesn't surprise me.
But
That's what these do.
That's what's happening. And once,
Well, it's been happening for years. I got a call from an 87-year-old man whose 69-year marriage just went south. And so his wife left. His daughter shows up at the house, and according to him, he was talking with her. And I don't know if he made reference to a firearm or what happened. He had flintlock muzzleloaders on the wall. He had a .22 rifle, Daughter calls the police. They charge him with domestic violence because apparently he doesn't know how. His daughter said he made a threat. So if he's convicted of domestic violence, he can never own or possess a firearm the rest of his life. And I said, unfortunately, in the state of Ohio still, they can take your muzzleloader, your antique firearms, but under federal law, antique firearms essentially aren't even guns. They're muzzleloaders, flintlocks, anything that were designed and built in the 1800s, late 1800s. So, and that's a tough situation. He said, I've never been in trouble in my life. And I said, just make sure you don't get convicted of domestic violence. But see, that's a problem. When you start doing things like that, they're ripe for abuse like that. That's why, comments like that, well, think about it. How many years ago was it that the kid was at school and made a handgun out of a Pop-Tart and he was expelled? That's when things go crazy. And that's what, whenever we give people the opportunity to take away another person's liberty, not everybody are good people, and they're going to use it to their advantage or disadvantage. Now, what I'm going to discuss now, I want everybody to pay attention to because it's particularly troublesome in my mind. And this is something that's in the new bill. RC 2317 talks about privileged communications with your doctor, more so with your doctor, with your dentist, with your nurse, or something like that. And what that is these amendments tie into the bill's changes to the mental health proceeding. But what they're talking about is on these privileged communications, they want to require the police to be able to mandatorily force those documents or those conversations to be produced. Generally existing privileges and communications under that section I cited prohibits testifying by and grants testimonial privilege to physicians, advanced practitioners, or nurses, dentists, from respecting those communications made in a medical diagnosis. Maybe I'm sick because I was taking drugs. They don't want me to be afraid to tell my doctor I was taking drugs and that's why I'm sick. That's why it's privileged. Whatever the doctor hears from me, my health is a paramount concern. And then, so the doctor couldn't be forced or couldn't be compelled to testify. Didn't have to turn over his notes when it was resulting to a medical diagnosis. Because remember, now we're talking about adding chronic alcoholism and adding drug dependency. Because of that, they want to be able to go up and say, no, we're on an active investigation. I need the notes. So they want to draft a law to compel the doctors and force the doctors to give them all your notes, your case notes, and then to be subpoenaed and testify in court. Remember, under the law, we want the sick to be healed first before anything. So if a law enforcement officer provides a written statement to a healthcare provider that states an official criminal investigation has begun regarding a specified person or criminal action or proceeding has been commenced against the person, the provider has to divulge any records related to a drug or alcohol testing relevant to the test, and it doesn't matter how long ago it was. So maybe I had a DUI 20 years ago, and they picked me up and I'm drunk tonight. So they want to try to use that with my condition tonight to prove that I'm a chronic alcoholic to deprive me of my constitutional rights. And I think whenever we start allowing the government to get in our bedrooms, to get in our doctor's offices, we have a real problem. And it has to be stopped. And that's when I think that's one of the greatest dangers that exists in this bill. To all of a sudden force and compel your doctor about private conversations that you've had and to disclose those to a police officer.
Sean, do you have a recommendation for the people here that when their doctor now asks them if they're depressed, if they're that whole list of questions that, what do you recommend? Do you have a recommendation for what to tell your doctor?
Well, that's tough. And it changes. Unfortunately, there's a difference if you're at the VA hospital and you're a veteran as to what you say, if you have PTSD or whatever else. As far as a recommendation, you want to be treated properly. So that information needs to be out there. So, but again, if you're depressed, they find out you're depressed and they go forward further and further. I can remember when I brought my dad from Pennsylvania to live with me. He was elderly, and Butler County Elderly Services came to the house. The first thing he asked me, do you have any guns? And I'm thinking, why in the world are you asking me if I have any guns? Well, the Obama administration at that time changed the rules, and they were asking everybody if they had guns. And of course, I don't have any guns. Who would have guns? So, But I mean, that's a tough question, because now you have to worry about losing substantive constitutional rights because you're trying to get some medical treatment done. But again, suicides are prevalent. I've been going through that last Sunday. One of my good friend's wife just committed suicide. Nobody knew. And so it's important that we take care of ourselves. And I always remind people that you never know what happened 15 minutes ago. When a police officer pulls you over and you don't think he's doing something right, now's not the time to argue at 2 o'clock at night on the side of the road. Wait until you call me and I'll argue it for you, because you never know what happened 15 minutes before that or an hour or yesterday. So we always have to be careful about that. So all it takes is a law enforcement officer to essentially give a written request. I have an active investigation. Give me all your notes and let me know what Joe's been telling you. And then let me know if he's ever have any alcohol-related illnesses his entire life. If you can find all that stuff, that'll be helpful too. But guess what makes this so easy? Who's been to the doctor's office recently and noticed that all their files are gone? All scanned, all on the computer, and everybody has access to everything. You switch a doctor, you go to a doctor in Miami Beach because you're on vacation and you're sick, boom, there's your whole medical history. We know it's not secure, but now with a simple push of a button, with that letter, there's your entire medical history. And how many of your liberties are being violated with the push of a button? You know, and you think about HIPAA laws and what they're allowed to know. This blows that stuff out of the water. Now, there's a bunch of other stuff in this bill. There's increased access to inpatient psychiatric care. Right now, you're looking at about 79% of all the psychiatric hospital beds in the state of Ohio are being used by people that were sent there by the courts, whether they're trying to get them competent to serve trial or whatever else could be happening. The Ohio Department of Mental Health and Addictive Services are working to create some kind of process where they can do more outpatient stuff with the heroin and opioid epidemic that's been just taking away so many of the hospital beds. They want to try to get early intervention as part of the 2019-20 biennium. The state's investing $675 million as wraparound services to schools to try to begin helping people and individualizing programs for them. I think if you look at some of the latest tragedies, especially the shooting in Florida, and it goes back to the Zimmerman case. Under the Obama administration, they didn't want to flag kids as being problems or being trouble. So they were ignoring and not entering stuff into their records. Then they're going on their way at 18 and they have a clean slate, but everybody knew, Stoneman, that he was going to kill somebody. So they're changing those rules and those laws to try to make them understand better what people are going through and to track them and finally start doing something about it. And again, that's a big problem to try to get your hands around. So it'll be interesting to see how that happens. They want to provide access to behavioral health services. The Ohio Department of Medicaid is investing $50 million in telehealth mental health services to students. So no matter where a child lives, they have access to mental care and mental health. They have risk factor and resource identification. Ohio Mental Health Services is working with communities to increase knowledge of risk factors to help people be able to identify when someone is at risk. And really, if you think about it, for so long, I always say, you look at everybody living under a bridge. 30 years ago, or maybe it was longer ago than that, when I was born in the 60s, they were in hospital getting help. But then all of a sudden, I think it was Democratic policy. They opened the hospital doors and you couldn't keep anybody anymore and nobody got treatment. Increased penalties for felons who illegally possess firearms. That's a feel-good piece of legislation in my view. Criminals don't care. They don't care if you have an increased penalty, but it sounds good. Increased penalties for violent felons who illegally possess firearms. We talked about that. The governor is calling the General Assembly to increase penalties for all felons. Again, he ran on the criminal justice reform platform. Increased penalties for people who commit felonies while possessing firearms. Increased penalties for brandishing a gun. Increased penalties for straw purchases. Increased penalties for illegally obtaining guns. Increased penalties for those who improperly provide firearms to minors. Let your 14-year-old kid go hunting without proper supervision, whatever that is. My father can make a determination when I was responsible enough to be out with my brother with a firearm. And I didn't have a bicycle helmet. I bumped my head a few times, but we all still made it. They're going to implement school tip lines. DeWine administration is expanding the state school safety tip line where the kids and adults can call or text anonymously. Number is 844-723-3764 with tips about potential school violence. I don't know how that's going to go. Social media monitoring 24/7. There's going to be hubs set up that are doing keyword searches. And so, George Orwell had it right, but he didn't realize that we were going to volunteer all this information. Community safety programs, operating budget also provides $9 million for that. I should have got a calculator and should have been adding all this stuff up. School safety and intervention programs, working closely with the Sandy Hook Promise Ohio schools. And the only thing that, the Sandy Hook Promise passed probably, I think, a couple weeks ago, unanimously. But the only thing that gave people heartburn is that's an anti-gun organization that was put together. So, and who knows what the final details or something like that's going to be. I mean, your kids and your grandkids, it's amazing what they're being taught and what they're not being taught. I started taking the opportunity to, my kids go to Lakota schools to start looking, they used to go to Lakota, to start looking at what was in their textbooks. And it was amazing. And I started encouraging everybody to look what your children are being taught. Keep in mind, overall, in my view, and I encourage anybody to get online and read the bill. That bill's sitting here. If anybody wants it, come up and grab it. That way I don't have to take it home and hurt my back. There's some good things in the bill, but overall, I oppose the bill because of all the different violations of our civil liberties that occur because of this bill, because I don't think they really know what's going on yet, and because they think it's okay to allow government intrusion into our private life with our doctors and our family. There's a lot of problems. There's some good things in the bill, Brandon, but before I would ever support any part of it, it's got to get across the street to the House and Senate, where they'll break all these points in this giant bill up, and you can take a look at things independently and decide, whether you want them or not. But some of the reporting processes that they're going to approve to make sure that this information gets put in, they're going to create a separate portal in the state of Ohio where there's only one place that all these records have to be entered into, and then from there, once they're entered, there's another group of people that all day long will be entering this information. So, yeah, so all those convictions that people shouldn't be carrying firearms or under disabilities, all those mental illness determinations are going to be entered in the system now. So that's good, and that's something that's needed to be done. Remember at the beginning, I read about all the warrants that nobody even knows about.
Sean, can we take a couple last questions
Okay.
before we, anybody, I just want to get a couple more questions in if anybody has them before we finish up.
You may have said this, and maybe I missed it, but we all want to live forever. We don't. We all have family members that passed away. You're cleaning the house out. You never knew it. Your grandpa's got a shotgun there. And do you have to register that? You just take it home?
No, you can just take it home right now under current law. There's no registration in the state of Ohio. I wish I could say that about other states, but I can remember I was in Connecticut speaking on the Connecticut State House Capitol steps shortly after Sandy Hook. And, about the craziness that was going on. And I walked into a gun store to be interviewed by somebody, and there's a sign on the desk that said, no ammunition can be purchased unless you have a registered gun for that caliber. So a couple things bother me. It was like an everyday thing to have registration in Connecticut. And then they're telling me that I can't buy ammunition unless I can show you a card that I have a 9mm registered, and so I can buy 9mm. So. But you know what? That's coming.
Anybody have any more questions they want to get in for our guest speaker? So Sean, how do people get a hold of you if they've got something they want to send you or a question or?
Well, I think you have all my contact information here. I don't have any cards. Usually I have a ton, but I ran out. If anybody wants to get their cell phones out right now, I'll give you my number. I give my number over national radio programs, so I don't care. It's 513-484-0142. Or I have an email that's pretty easy. S Maloney, so SMALONEY ESQ betty@gmail.com.
We'll throw that up on the website tomorrow. The other thing I've never asked you before is, what is your sweet spot for the kind of cases you like that you like to take on? I mean, when should somebody contact you?
Anytime all of a sudden you walk into the sheriff's department, they say they can't issue a permit, or anytime you're forced to use a firearm in self-defense, and you should contact an attorney immediately. I started a company called Second Call Defense, and the website secondcalldefense.org, simply because for years I was representing people that had legally and properly used the firearm in self-defense, but they were being persecuted and treated like the bad guy or the bad girl, simply because they used the firearm. And one day, after a particularly egregious case, and a judge just really took me aback, I said, you know what, there's got to be a better way to do this. So I started that program so that anybody, for a small monthly fee, would have training and education. And then if anything happened, we immediately provide bail for you up to $100,000, and that's 10%, so that's $1 million bail. 24-hour emergency hotline, immediate attorney assistance, retainer fee wherever the shooting takes place. I say, I know who I'm going to retain if something happens here in Butler, or Hamilton, or Warren counties, but I'm on vacation. I have no idea. I think probably Joe and I and Buckeye Firearms Foundation, we sued the city of Cincinnati and the city of Columbus. We sued them. They put a bump stock ban on, and also they banned any kind of trigger you can imagine. So even if you did a trigger job on your firearm, it was illegal, and they violated Ohio's preemption laws. So as soon as they did that, we sued them and won. So really almost anything that do with firearms. I've been a criminal defense attorney for many years, and it's amazing when I'm talking to that I have to tell a law-abiding citizen who did everything to save their life that you need a criminal defense attorney, because you have an affirmative defense of self-defense in the United States, which means that you're admitting, yeah, I killed him or her, but I had a reason to do that, but you're still considered the defendant, even in your own home. And when I think people realize that, things change. So give me a call if anybody ever has any questions, no matter if it's about the topic here tonight or anything that's going on. Get involved, stay involved. Phone numbers, phone calls matter to your state reps and your state senators. You won't believe how phone calls matter. They still do.
Last question, where's this whole DeWine, where's this at? Is it going to go through committees, or where are we at with it?
This bill, Senate Bill 221, was just introduced, and it hasn't been assigned to a committee to the best of my knowledge. Larry Householder on the House side, it was admitted in the Senate. Larry Householder has his own companion legislation, and he's truly a pro-gun guy 100% of the way. So I assume his legislation will improve as it goes along. They're just trying to make the best thing they can do. So it'll be up for committee hearings probably within the next week or two. And I'm not sure what's going to happen. I don't know. I mean, I don't know if they're going to take this one bill and start making a bunch of little bills, which is, yeah, it's a Senate bill right now. Senate Bill 221. Not a comparable one. It's going to start in the Senate. And then there's Larry Householder has a House bill. It's a plumber bill. And it was terrible when I first saw it, but they wanted to make it right. They just didn't know how to do it. And so that's what I've been involved in there. And also when they started out, their mental health protection order said basically you're mentally ill, or you're a chronic alcoholic, or you're drug dependent. So they flat out created 2 levels of mental illness, alcohol and drugs, and then normal mental illness. I said, you can't do that. I said, you can't expand the definition of mental illness to suit your purposes. So, and they understood the mistake that they made. And you got to understand, these guys deal with so many different stuff. They need to talk to the experts in the area. They need to hear from their constituents. They need to know, because you give them the shoulders and the backbone to stand up and do the right thing.
How could they know? Let's thank our guests. What a great presentation. Thank you so much. Appreciate you coming. Sean's been so great about sharing his time with us. Hey, one last thing I wanted to let you know about an upcoming session. So Sean mentioned you should know what your kids are reading, or your grandkids in my case. And next Thursday night, when we're having our class about chess, that I know Betty's was telling you she's super engaged about. Before that class, so a few of our classes we're having second speakers. We're having a guest from the state school board come in. Her name is Jenny Kilgore. She lives in Glendale. And she's going to come in and talk to you about some of the really crazy things that our kids are being forced to learn about. When she told me about a couple of them, I cringed, and that's when I asked her to come in. She'll be here next Thursday night from about 7:05 to 7:20, and then we have to put our thinking caps on. So everybody have a great night. Thank you for coming.
So what's with the pennies?
I'm not.